Hello, good morning, all my students. Welcome to this online classroom again this morning. Okay, so this morning we are going to discuss uh, the issue concerning the voidability. Okay, that is situation where a juristic act becomes voidable in Thai law. Okay, so when a juristic act becomes voidable, what are going to be the legal consequences of voidability? Okay, so last week, remember, we discussed consequences of a juristic act which becomes void. Okay, so today we will see the legal consequences of a juristic act which becomes voidable, not void. Okay, so when a juristic act becomes voidable, then there are legal consequences. Okay, we will see general consequences and also consequences upon avoidance. Okay, so we will see this in this lecture this morning. Okay, we begin with general consequences of a voidable act. Okay, when a juristic act becomes voidable, then the general consequences are as follows. Okay, the juristic in question, the juristic act in questions will remains valid until it is avoided. Okay, so this is the general consequence of a juristic act which becomes voidable. Okay, when a juristic act becomes voidable, that it will remains valid until it is avoided. Okay, you can say that this is something different from a juristic act which becomes void. Remember last week we discussed, the consequences of a juristic act which becomes void. We have seen that when a juristic act becomes void, it is automatic nullity. Okay, it is incapable of ratification. But when a juristic act becomes voidable, not void, okay, it is not nullity. It remains valid until it is avoided. Okay, when I say avoided here, okay, when something is avoided, that means that somebody just challenges that is not valid. Okay, if there is no challenge that it is invalid, it will always be valid. Okay, it will always remains valid until it is avoided. Okay, so when somebody avoids a juristic act which is voidable, that means that that person just declares, okay, that juristic act to be invalid. If there is no declaration that it is invalid, that juristic act will remain valid. Okay, so there's a difference between a juristic act which is void and a juristic act which becomes merely voidable. Again, when a juristic act becomes void, it is automatic nullity. Okay, it will not remain valid. But when a juristic act becomes voidable, it remains valid until it is avoided by somebody. Okay, when it is avoided, that means that somebody just declares that that is invalid. If there is no such declaration by the person concerned, that juristic act which becomes voidable will remains valid. Okay, so this is the difference between a void act and a voidable act. Okay, so again, we are now discussing, the general consequence of voidability. When a juristic act becomes voidable, it remains again valid until it is avoided. Okay, we will discuss later who is going to be, entitled by law to avoid a voidable act. Okay, now we just want to just see that, well, the legal consequence of, a juristic act which becomes voidable is that it remains valid until it is avoided by the person allowed by law. Okay, now the inter party, when the law says that a juristic act which becomes voidable will remains valid until it is avoided. That means that there is choices to be made by the inter party. When the a juristic act becomes voidable, it doesn't mean that that the inter party will always decide to avoid that Juristic Act. The injured party may have choices. Firstly, the injured party may just do nothing, okay? He may just do nothing. He just let the Juristic Act stand, okay? So if he does nothing, he does not want to avoid the Juristic Act, that Juristic Act will remain valid, okay? Or he may just elect to avoid the Juristic Act if he thinks fit, okay? The person who is injured by that Voidable Act may just elect to avoid the Juristic Act. When it is avoided, okay, we will see the consequences upon avoidance, okay? So if the injured party does not want to avoid the Juristic Act consent, okay, it will remain valid until it is avoided. But if the injured party elects to avoid the Voidable Juristic Act, okay, then we will see the consequences upon avoidance later, okay? Now, what is going to be another choice? Another choice is to ratify the Juristic Act in question, okay? Let's say that, okay, we have a contract which is made by a minor. We have seen that, when a minor wants to make a contract, okay, a minor needs to get consent from the minor's legal representatives, okay? In most cases, the legal representatives of the minors are the minor's parents, okay? Let's suppose that, the minors just makes a contract without consent of his parents, so that Juristic Act will become voidable in this case, okay? So let's suppose that the parents become now aware of this contract, the contract which has been made without the parents' consent, okay? The parents may just let the juristic extent. The parents do nothing, okay? The parents do not want to avoid the Juristic Act. Or the parents may just elect to avoid the Juristic Act in question, okay? So when it is avoided, okay, we will see later that, okay, the law says that when a Voidable Juristic Act is avoided, it will become void from the beginning, okay? We will look at that later, okay? Or the parents, when the parents become aware of that contract, the parents may decide to ratify that contract. The parents may ratify that Juristic Act, which becomes voidable. Okay, that we will see later what is going to be the consequence of ratification. Okay, so what I'm saying now is that, okay, it does not mean that when a Juristic Act becomes voidable, okay, it will cease to have legal effect. Okay, the law just allows choices to be made by the person concerned. Okay, the person concerned may, decide to, do nothing. Okay, the person concerned may decide to let the Juristic Act stand, or the person concerned may also elect to avoid the Juristic Act in question. Okay, or the person allowed by law may also decide to ratify the Juristic Act in question. Okay, so these are choices to be made by persons allowed by law. Okay, we will look at the point concerning persons allowed by law later. Okay, it doesn't mean that everybody can just make these choices. Okay, the persons who are entitled by law to make these choices, okay, are also listed by the law. Okay, we will see that later, right? Now, I just would like to bring to your attention that, okay, when a Juristic Act, okay, becomes voidable, okay, so there are choices to be made by persons concerned. Okay, now let's have a look at the example of choices by the injured party. Okay, let's suppose that we have a Juristic Act. Let's say that it is a contract, okay? A contract which is made by mistake. We have taken a lesson on mistake, remember? In Thai law, a mistake as to the quality of a person or of the quality of property. Yeah. Okay, which is the subject matter of a Juristic Act. Okay, the mistake as to the quality of the person which which is the party to jurisdict, or the mistake as to the quality of the property, okay, which is the subject matter of a jurisdict, will render that jurisdict to be voidable. Remember that when we have seen the legal consequences of a mistake in Thai law, okay, when a jurisdict is procured by mistake, okay, the jurisdict may be void or may be voidable as the case may be. In the event that the mistake in question is the mistake as to an essential subject matter of a jurisdict, then that jurisdict will become void. But when the mistake in question, it is the mistake as to the quality of a person or the quality of the property, okay, which is which is the subject matter of a jurisdict. It may be the mistake of the quality of the person, which is the party to the jurisdict, or it may be the mistake as to the quality of the property, which is the subject matter of the jurisdict. In this case, that mistake, the mistake as to the quality will render the jurisdict in question to be merely voidable, not void. Okay, we have in this example, when we remember when we have dealt with the principles of law or principles of law regarding mistake in Thai law. Okay, we have this. Okay, we have these facts as the example of the mistake as to the quality of the person. Okay, let's suppose that we have A and B. Okay, we have A and B. Okay, let's suppose that A intended to employ somebody as the interpreter. Okay, and A expected the interpreter to be fluent both in the English and French, because he intended to have the interpreter to coordinate business projects in Belgium. Okay, you know that in Belgium, this country has both English, has also French as one of the official languages, so that the A who intended to employ B as the interpreter, okay, expected B to be also fluent in French, because A also ran the business, okay, the business projects in Belgium, okay, where the French language is essential. Okay, so that in this case, A expected B to be fluent in French. But the thing is that when A employed B, okay, he misbelieved that B was fluent in French as well. In fact, B knew too little French. Okay, B did not become fluent in French at all. Okay, so the thing is that in this case, the contract in question, what is the contract here? The employment contract. Okay, would this contract become voidable on the ground of mistake? We have seen that the mistake in this case, it is a mistake as to the quality of whom? The quality of the person. Okay, the quality of the interpreter. Okay, so in this case, okay, when this employment contract has been made by mistake as to the quality of the person, okay, so the consequence is that this employment contract would become what? Would become voidable. Okay, so it would become voidable. Okay, so that it would become voidable on the ground of mistake, as to the quality of the person, okay, that was the party to the jurisdict. Okay, so in this case, it does not mean that A, the employer would decide to just put an end to this contract, because A could have choices. Remember, A as the injured party could just first let the contract stand, or he could just elect to avoid the contract, okay, because the contract becomes voidable, so that A, the employer, could just elect to avoid the contract, or A, if he does not want to, to put an end to this contract, okay, in addition to doing nothing, okay, he may also decide to ratify this contract. If he ratifies his contract, that means that he is going to keep permanent, okay, the permanent, he is going to recognize this contract as permanently valid. Okay, we will talk about the consequence of ratification later. So back to this example. So from this example, when this employment contract becomes voidable, okay, A, the employer may just have choices. He may just, that he may just do nothing. He may just allow this contract to stand, or he may just avoid this contract in order for this contract to become void. Okay, it is not void from the beginning, but if A elects to avoid the contract will become void from the beginning. Okay, because the law say that when a Juristic Act which is voidable is avoided, then it is deemed to have been void from the beginning. We will look at this later, okay? Or the employer may also elect to ratify this contract, okay? So from this example, there are three choices to be made by A as the employer, okay? Now, we are going to also look at what? We are going to look at the consequences when a Juristic Act which becomes voidable, okay, is avoided. So what are going to be consequences upon avoidance? When a voidable act is avoided by the person allowed by law, okay, there are some consequences, okay. The consequences upon avoidance are, they embody in section 176, okay, 176. Okay, if we look at 176 here, okay, so maybe we are going to have a look at, the wording of 176 first, and then from this wording, we are going to analyze the consequences, okay. 176 provides as follows, okay. Section 176 provides, in fact, in paragraph 1, okay. Section 176, paragraph 1 provides as follows. A voidable act upon avoidance shall be deemed to have been void ab initio. You have to record the word ab initio. Okay, this is the Latin expression, okay, which means from the beginning. Okay, again, a voidable act upon avoidance shall be deemed to have been void ab initio, and the parties shall be restored to original positions. Okay, if it is impossible to effect such restitution, okay, the parties shall instead be entitled to damages in compensation therefor. So from these provisions, okay, from the provisions of section 176, paragraph 1, we can see that, okay, the consequences of a Juristic Act which is voidable, okay, that are this upon it is avoidance, okay, upon it is avoided, okay, when a voidable act is avoided, the first consequence is that it is nullity, but it is retrospective nullity. It is not void at the beginning. Remember, when a Juristic Act becomes voidable, it is not void from the beginning. Remember, we have seen that when a Juristic Act becomes voidable, it remains valid until it is avoided. So from the beginning, it is not void. It remains valid until it is avoided. Okay, but when it is avoided by the person who is allowed by law, the very first consequence is that, okay, it is nullity. It is retrospective nullity, because the law say that, okay, when it is avoided, it is deemed to have been void ab initio. So this is the retrospective nullity. It is not void from the beginning, but when it is avoided, when a voidable act is avoided by the person who is allowed by law, that juristic act will become void, okay? It will be deemed to have been void ab initio, so that this is the retrospective nullity. Okay, this is the very first consequence of what? Of a juristic act which is becomes void and which is avoided by the person allowed by law. Now, the second consequence upon avoidance is this restitution, okay? Because if you look at, again, section 176, paragraph 1, in addition to providing that when a juristic act becomes voided, when a juristic act is voided, it will be deemed to have been void ab initio. This provision also goes on to say that the parties to that juristic act, okay, shall be restored to original positions. So to be restored to original position, that is the restitution, okay. So these are the two, okay, consequences of a voidable act when it is avoided by the person allowed by law, okay. So now we are going to have a look at restitution, okay. The retrospective nullity, that is something clear, but now we are going to have a look at the second consequence here, the restitution, okay. When the law directs restitution in the events where a juristic act which is voidable is avoided by a person allowed by law, okay. Remember with respect to we have seen restitution, okay, in the case of Avoid Act. We have seen this already, okay, in the previous lesson. If we look at, the a juristic act which becomes void, the law, okay, the civil and commercial code also says something about restitution, okay. Remember, we have section 172 in the case of a void act. In the case of a void act, section 172 directs restitution, okay. According to section 172, a void act is incapable of rectification and any interested person may allege nullity thereof. And paragraph 2 also says if a return of property is to be made as a consequence of a void act, the provisions of undue enrichment of this code shall apply thereto. That means that remember that in the case of a void act, the law says that if property needs to be returned, then a return of property will have to be governed by the laws on undue enrichment. We have seen this already, okay? So this is the restitution in the case of a void act. What about, restitution in the case of a voidable act? In the case of a voidable act, okay, voidable act, the civil and commercial code of Thailand also directs, the restitution, okay. But the recessionary effect is embodied in section 176, paragraph 1 as well, okay. Just now we have seen, 176 paragraph 1, okay. If you look at, if you look at the later part of the 176 paragraph 1, okay, the law talks about, the being restored to original position. Remember, this provision of law, section 176 paragraph 1 says again, okay, a voidable act upon avoidance shall be deemed to have been void ab initio. Remember, this is the retrospective nullity. And this provision of law also says, and the parties shall be restored to original positions. See? So, restoration, okay, restoration to original positions, this is the what? This is the restitution. Okay? So, that means that the law, the civil and commercial code of Thailand, okay, that speaks of restitution, okay, in the cases of what? In case of void acts and also in cases of voidable act. But in the case of a voidable act, it just It's just when the CCC, the civil and commercial code just say that the parties to the juristic in question will have to be restored to their original positions. Okay, if it is impossible to effect such restitution, then the parties shall instead be entitled to damages in compensation therefore. Okay, if we compare, okay, the provisions of law, if we compare the provisions of the civil and commercial code with respect to restitution, we can see that the code, okay, directs restitution, right, both in voidness cases and in voidability cases. Put simply, the law, the CCC, directs restitution, okay, both in the case where a juristic act becomes void and also in the case where a juristic act becomes voidable. In the case where a juristic act becomes void, restitution, okay, is embodied in section 172, which say that if a return of property is to be made as a consequence of a void act, then the provisions on undue enrichment of this code shall apply thereto. But in the case where a juristic act becomes voidable, then we have section 176, okay, paragraph 1, which directs restitution, okay, by saying that, okay, a voidable act upon avoidance shall be deemed to have been void ab initio, and the parties shall be restored to original positions. If it is impossible to effect such restitution, the parties shall instead be entitled to the damages in compensation therefore. So this is what we are going to discuss, okay, in detail. Okay, now coming to the restitution, okay, in the case of a voidable act. Okay, again, section 176, paragraph 1, say that, okay, say that the parties to the juristic act which becomes voidable, okay, when it is voided, will be restored to their original positions. So this means that there may be a return of property, okay? For example, in the case of a contract of sale, I'm going to just cite the contract of sale as an example, because this is a very easy example, okay? Remember, in a contract of sale, there are two parties. The first one is the seller, the second one is the buyer. Let's suppose that a contract of sale becomes voidable on the ground of mistake as to the quality of the property. In that case, section 176, paragraph 1 directs restitution, okay, by saying that the parties shall be restored to original positions. That means that we will have to look at the original position, okay, original position of the two parties. If the seller has made delivery, right, the seller has the what? The seller has the goods or the property, okay? So that if the seller has delivered the property to the buyer, then the seller is what? The seller can get what? The seller can get that property back. So that the buyer is required to return the property to the seller. How about the price? Of course, in a contract of sale, the buyer may have paid the what? The buyer may have paid the price to the seller. So if the seller has received money, okay, as the price, then the seller is required to return the price to the buyer. So both parties, the sellers and the buyer, will have to return what each party has received from the other party, okay? The seller is required to return the price to the buyer. Similarly, the buyer is required to return the what? To return the property to the seller, so that the two parties, the seller and the buyer, are, again, to use the word as used in section 176, paragraph 1, both the seller and the buyer are restored to original positions. Okay, so this is the restitution. Okay, in the case of a voidable act, which is avoided by the party which is allowed by law. Okay, of course, means that in this case, where in the case of a contract of sale, okay, we have seen that both parties, the sellers and the buyer, are required to just what? Are required to return what each party has received from the other. How about I mean that if one of the party is not able to return what has been received from the other party, because it is impossible to return the property. Okay, in that case, if we get back to section 176 paragraph 1, okay, we can see that section 176 paragraph 1 says something that at the ending part of this provision. Okay, again, this is when embodied in this sentence. If it is impossible to effect such restitution, okay, the parties shall instead be entitled to damages in compensation. Therefore, that means that that even though the law directs restitution, okay, by requiring each party to return what has been received from the other party, but sometimes it may occur that a return of property is impossible. In the case where a return of property, or I should say, in the case where restitution becomes impossible, then the law say that in that case, the party who is otherwise required to return, property will have to pay damages instead. When a return of property is impossible, okay, so the return cannot be made. In that case, the person who is required by law to make the return will have to pay damages instead. Okay, you may wonder, why on earth a return of property becomes impossible? Well, there are many reasons. There are at least 3 reasons here. We have at least 3 situations here in which, okay, a return of property becomes impossible when a voidable act is avoided by the person allowed by law. Okay, one of the party may find that a return of property is impossible. In that case, the law say that the party who is required by law to effect restitution will have to pay damages instead. Okay, we are looking at situations where a return of property is impossible. Okay, in the first situation, okay, a return of property may be impossible because what? Because the property in question may have been damaged or destroyed totally. Okay, so that the property which is required by law to be returned is not there anymore. It has been damaged totally, or it has been destroyed totally. So in that case, it's obvious that a return of the property is impossible. So in the case like this, then the party who is required by law to make a return will have to pay compensation. Okay, will have to pay damages. Okay, in compensation for the return of property, because the return is impossible. So the party who is required by law to make the return will have to pay damages, okay, in compensation for the return of the property in question. Okay, so we have also another situation in which a return of property may be impossible. Okay, maybe the property has been delivered under a voidable act, a voidable contract, okay, and that voidable contract is subsequently avoided. Okay, when it is avoided, remember the law says that it will becomes void from the beginning, so that there may be restitution. Okay, but sometimes restitution by the return of the property is impossible because the person who has received the property, let's suppose that the buyer who has received the property from the seller has sold the property to a third party. Okay, we can have a look at this diagram. Sometimes, the return of property becomes impossible, or the restitution becomes impossible because the property in question has been subsequently transferred to a third person, and the third person is protected by law. Okay, the reason why the return of property cannot be made is because the property in question has subsequently been transferred to a third person who enjoys protection by law, so that the property cannot be returned to the person entitled. Okay, let's have a look at a contract of sale here. Let's suppose that we have in this case a contract of sale. Okay, let's suppose that this person, this seller has made a contract of sale of this car to the buyer. Let's suppose that the seller is A, the buyer is B. A has made a contract for a sale of this car to B. Okay, and let's suppose that this contract becomes voidable. Maybe because of the mistake. Let's suppose that the parties made a mistake as to the quality of this car. Thai law says that in the case of a mistake as to the quality of the property, which is the subject matter of the Juristic Act, then that mistake will render the Juristic in question to be voidable, so that this contract between A and B becomes voidable. Okay, so when it becomes voidable, let's suppose that in this case, A, the seller, avoids this contract. Remember, we have seen that there is the legal consequence flowing from avoidance. Remember, when this contract is avoided, the legal consequence is that it is deemed to have been void from the beginning, and the parties shall be restored to their original position. So, when the seller avoid this contract, then the seller will have to get this car back. Remember, because this is the restitution directed by Section 176. If we get back to 176 of the CCC say that the parties shall be restored to original positions. So in this case, the seller here shall have this car back from the buyer. Okay, but the thing is that Section 176, Section 176 also say that if it is impossible to effect such restitution, the parties shall instead be entitled to damages in compensation therefor. So in this case, if the car is still there, then B, the buyer, will have to return the car to A. The thing is that this car is still there. This car has not been destroyed. This car has not been damaged totally. Okay? But the thing is that in this case, it is impossible for A to get the car back because before A avoided this contract, B sold this car to C. When B sold this car to C, C here is the third party. Okay? Remember the law. In some cases, the law protects the third party. Okay, we are going to look at the protection of third parties later. Okay, but for the other papers here, I'm going to say that in this case, the law say that in the event where the third parties enjoys the third parties will enjoy, protection by law if the third party acts in good faith and the third party has acquired the property for value. Okay, we will see that later. So, put simply, the third party here is protected by law. So, when the third party is protected by law, the third party does not need to, return the car to the original owner. Okay, even a contract between A and B becomes voidable and is later voided by A, so that it will become void ab initio, and then section 176 directs restitution. But in this case, restitution of the car restitution of this car in A's favor is impossible because the car is in C's, the third party's possession, and C is protected by law. When C is protected by law, it is impossible to return this car to A. B, cannot return this car to A. So, in a contract between A and B, under the contract between A and B, it is impossible to effect restitution. Okay, so in this case, section 176 say that in the case where restitutions become impossible, so the parties who has the obligation to effect restitution shall do what? Shall instead, pay damages in compensations. Okay, so this is the compensation by way of damages in the case where a return of property. In the case of restitution by a return of property becomes impossible. In this case, the law say that the person who is required to effect restitution will have to make compensation by way of paying damages instead. So back to this case, in the event where B is unable to effect restitution in A's favor because restitution becomes impossible, in this case B will have to pay compensation to A instead. Okay, so this is the consequence of section 176 paragraph 1. Okay, remember, we are going to have a look at one more example. In fact, this example has been drawn from a real case, which has been brought before the Supreme Court. Okay, this is the decisions of the Supreme Court. Okay, in the 1988. Okay, it is in fact, in this case, it is concerned with a contract of employment. A contract of employment was made between PTT. It will say that PTT has not been, PTT is not yet, a company. At the time, PTT was, the Petroleum Authority of Thailand. Okay, so in this case, there was a contract between PTT. Okay, if you look, if you don't want to know the Thai name, PTT การปิโตรเลียมแห่งประเทศไทย. PTT Petroleum. At the time when this case was brought before the Supreme Court, PTT became the Petroleum Authority of Thailand. Okay, now the Petroleum Authority of Thailand has become a public company. Okay, so at the time it was the Petroleum Authority of Thailand. So that PTT, let's suppose that PTT here is A, the other one is B. A as a state enterprise. As a state enterprise, A took B into employment. The thing is that at the time when A took B into employment under a contract of employment, A believed that B was below 60 years of age. In fact, at the time when this contract was made between A and B, B was over 60 years of age. So we can see that in this case, a contract of employment between A and B was made by a mistake. Mistake as to what? A mistake as to the quality of the person. Because A misbelieved that B was at the time under 60. In fact, B was at the time over 60 years of age, so that the contract between A and B was made by a mistake as to the quality of this person. So that this contract became what? This contract became voidable. Now, when it became voidable, remember, what were the legal consequences of this contract? Remember, there are two legal consequences. First, what? First, it is what? If we get back to, the consequences of something, a juristic which is voidable, the general consequence is that it remains valid until it is voided. But in this case, PTT avoided this contract. So when PTT avoided this contract, okay, we have seen that the consequences, okay, the consequences upon avoidance are first, retrospective nullity, so that when PTT avoided this contract which became voidable would become void ab initio, because section 176 say that upon its avoidance it would become void ab initio. And then, okay, we also have the second consequence here, the restitution. Okay, section 176 say that the parties are restored to original position. So back to this case, when section 76 say that the parties must be restored to original position, that means that, okay, if PTT made payment to this man, the employer, then this employer would have to okay, return the money, okay, which this man had received from PTT. So all the salaries which had been paid by PTT would have to be returned by this employee. And how about the return to be made by PTT? What did PTT have from this man? Of course, PTT had received what? Before avoidance by PTT, before PTT avoided this contract, PTT had received what? The service from this man. Because this man, the employee, had performed the work for the employer. So in this case, how could this employer return the service? Back to section 176 here. Back to 176, remember, 176 say what? 176 paragraph 1 say that, okay, the parties shall be restored to original positions if it is impossible to effect such restitution, then the parties shall instead be entitled to damages in compensation therefore. So in this case, if we get back to this diagram here, this picture here, we can see that PTT, the employer, had received the service from this employee. How could the employer just return the service to the employee? It would be just impossible. So this is a case where restitutions became impossible. So section 176 paragraph 1 say that when restitution became impossible, then the party would have to do what? The party would have to pay compensation, okay? The party would have to pay damages in compensation. So in this case, it was impossible for PTT to return the work or to return the service which had been performed by this employee. So in this case, PTT would have to pay damages in compensation. Put simply, PTT would have to compensate this employee by way of what? By way of paying damages. So let's suppose that the service which had been rendered by this employee, okay, the service was worth 10 million baht. So that in this case, PTT would have to pay 10 million baht to the employee, okay, in compensation for what? In compensation for the service which had been rendered by this employee. Okay, this is because the return of the service was impossible in this case, so that the employer here would have to pay damages in compensation for the return of the service which became impossible. Right. So in this case, back to the facts in this case, okay, which is of course the real story brought before the Supreme Court. Okay, so when the contract of employment between PDT and this employee was avoided, okay, it became void, so that okay there would be the restitution, okay, on the part of the salary restitution was possible, so that this employee would in fact have to return all the pay back to PDT, but on the part of the service which had been rendered by this employee, it was impossible for PDT to return this service, so that in this case, section 176, paragraph 1, they say that when the return of service here became impossible, then PDT would have to pay damages to the other party in compensation for the return of the service. So put simply, PDT would have to pay money to this man as damages in compensation for the return of this service, which became impossible, right? But in this case, the Supreme Court said, okay, according to section 176, I mean PDT, you will have to return, you will have to pay damages to this man in compensation for the service which you had received from this man. But you don't need to do so, because this man has received what? This employee had received salaries from you. So, in fact, this man would have to return all the salaries to PDT. But in this case, this man would not need to return these salaries, because the Supreme Court regarded these salaries as what? As the damages, that to be made by PDT to this man. The law say that PDT, when PDT could not, return the service to this man, PDT would have to pay damages in compensation. But in this case, PDT did not need to pay anymore, because this man was obligated to return all the salaries. So in this case, the Supreme Court regarded that all the salaries which had been received by this man, amounted to what? Amounted to the compensation, made by the PDT to this man, for the service rendered by this man to PDT. So in this case, if we get back to section 176 here, remember that we are talking about we are now talking about the restitution directed by section 176. Again, 176 say that the both parties, when a jurisdiction becomes voidable and is avoided, then both parties shall be restored to their original positions. But in the case where the restitution becomes impossible, then the parties shall just pay damages in compensation, so that in this case the Supreme Court, the Supreme Court just rendered judgment in a way that PDT did not need to just pay damages again, because PDT would regard that all the salaries which had been received by this man, all the salaries which had been received by this man, were the damages to be made by PDT to this man, under section 176, paragraph 1. So this is a very, very strong example. Now, we are going to look at a very, very interesting issue, in relation to restitution. We have seen that the law directs restitution in the event where a jurisdiction which is voidable is avoided by the person allowed by law. Upon avoidance, then the parties shall be restored to their original positions. So that is the restitution directed by law, okay? So when each party has to return the property to the other party, let's suppose that we have A and B. Look at this diagram here. We have A and B. Supposing that we have a contract between A and B here. Let's suppose that this is a contract of sale, of a female pig, okay, made between A and B, and let's suppose that this contract becomes voidable, okay, that on the ground of, let's say that on the ground of what? On the ground of, let's say that it is voidable on the ground of legal capacity. Let's suppose that at the time of sale, let's suppose that the A was a minor, and A as a minor sold this female pig to B with the consent of its parents, so that the contract between A and B here has to become voidable. And let's suppose that when its parents avoid this contract between A and B will be deemed to be void from the beginning, and each party, both A and B, shall be restored to their original position according to section 176 paragraph 1, okay? So that B, the buyer, will have to return this female pig to A, the seller. A is the seller, B is the buyer. When a contract of sale between A and B becomes voidable, and this contract is subsequently avoided, it becomes void, okay, and then each party is required by law to do what? To make a return of what has been received from the other party. So in this case, A, okay, the seller shall get the pig back. B is required by law to return this pig to A, so that A needs to be restored to A's original position. Right. Now, the interesting issue is this. The interesting issue is, okay, that is centered on the fruits. We have a very interesting issues concerning the fruits. Fruits which accrue on the property which is required to be returned by law. Okay, if the female pig has no offspring, then fine. Okay, it's obvious that B, the buyer, will have to return this female pig to A. But what about this? At the time when this contract between A and B is voided, okay, at that time, this female pig has given birth to, let's suppose that, to offsprings. This female pig has given birth to the piglets, too many, baby pigs here. So in this case, when this female pig has given birth to many baby pigs like this, okay, will be in this case, okay, be required by law to return all these piglets as well. You have to bear in mind that all these piglets are the what? Are the fruits. Okay, in Thai dog pon. All these piglets are the natural fruits of this property. Okay, the question which arises now is whether or not the person who is required by law to effect the restitution, okay, is under obligation to return the fruits of the property to the person entitled to the property as well. Okay, so in this case, okay, when we encounter a case like this, okay, when we are presented with this question, are fruits required to be returned? Okay, when we have this question, how do we answer this question? What is going to be the answer to this question? Okay, will be in this case be required by law to return all these piglets, because all these piglets are the fruits of this female pig, as well. Okay, this is the question. Okay, so in this case, when we are dealing with the question concerning the fruits of the property required by law to be returned, okay, we can answer the question. We can answer the question as to whether or not B is required by law to return the fruits, okay, of the property like this. We can just resort to, section 1376 in conjunction with the provision on undue enrichment. Okay, how does we approach this? We are going to look at, the section 1376, which speaks of a return of the fruits arising from the property, okay? According to 1376, according to section 1376 of the Civil and Commercial Code, okay, if property is required to be returned to the person entitled to recover it, the provisions of section 412 to 418 of this code on undue enrichment shall apply mutatis mutandis. That means that, okay, in the case where a person has to return property, okay, to the person who is entitled by law to have that property back, then we will have to apply section 412 to 418, which are provisions of the law on undue enrichment. We will have to apply these sections, okay, 412 to 418 to the return of of property as well. And if we look at section 415 paragraph 1, okay, remember 415 paragraph 1, it is the provision, okay, directed by section 1376 to apply to this case mutatis mutandis. 415 paragraph 1 provides as follows: a person who has received property in good faith shall be entitled to acquire fruits accruing on such property as long as he remains in good faith. Meaning what? Meaning that, that if any person is required to return the property, then if the person is honest, okay, if the person who has received the property, okay, if he is honest, if he has received property in good faith, okay, then if the property has some fruits, as long as the person who is required by law to return the property, okay, is honest, he does not need to return the fruits, okay? He is entitled to acquire the fruits accruing on such property, as long as he remains in good faith, so that in this case, even though the contract between A and B becomes voidable, and it is avoided by, let's say, by A, so that it becomes void, and then when it becomes void ab initio, section 176 directs restitution, okay, by requiring B to make a return of this property to A, okay. In this case, section 1376 in conjunction with section 415 says that, okay, in the case where B, in the case where the person who is required by law to return the property, okay, in the case where this person, the person who is required by law to return the property, okay, has acquired this property in good faith, this person does not need to return the fruits which accrue on this property, as long as this person, okay, is in good faith. As long as this person, okay, remains in good faith, this person does not need to return the fruits, the fruits accruing on the property required by law to be returned. Okay, so back to this picture here. As long as B is honest, as long as B remains in good faith, he remains in good faith because he does not know, that he does not know, that this contract becomes voidable. Maybe, at the time when A sold this pig to B, maybe A, even though at the time she was a minor, but she looked very old. She looked much older than her age, so that B did not know at all that, at the time of sale, A was a minor. So that when B received this pig from A, he did not realize at all that the contract between A and B became voidable. The buyer here, B, B believed all along from the beginning that the contract between A and B was fine. The contract between A and B was valid. Okay, so as long as B remained in good faith, B did not know anything. B did not know at all that the contract between A and B became voidable. In this case, when B remains in good faith, even though later A avoided this contract, or A's parents avoided this contract, so that the law section 176 directs restitution. But B, given that B remains in good faith, B is required by law to return only the property here, this female pig. But B can just host all these piglets. B is not required by law to return the fruits which accrue on this pig. Okay, so this is the legal consequence flowing from the application of section 1376. In conjunction with section 415. So the consequence of this one is what? Is that B is not required by law to return the piglets. So my explanation in fact is based upon this example here, the sale of the female pig. So again, we have another picture here, but the facts seem to be the same as the one which I have a while ago addressed to you. Let's suppose that this boy, at the time when he sold this pig to B, this boy was 19-years old, but he looks very old, see? Nobody knew that, that this boy was 19 at the time, because at the time when he made a contract with B, this boy looked very old, so that B did not know at all that this contract would have a problem. So when this boy sold this pig to the buyer, this contract became voidable because this boy did not get consent from his parents. The boy, the minor, can just make a juristic act only upon consent from his legal representatives. In this case, this 19-year-old boy sold this pig to this buyer without consent from his parents, so that the contract between this boy and this buyer just became voidable. So let's suppose that the parents of this boy just avoided this contract so that it became void ab initio, and then the law, remember section 176 paragraph 1, require this buyer to just return this property to this boy, the seller. In this case, at the time when this contract was avoided, this pig has given birth to these 3 piglets. In this case, this buyer did not know anything about the fact that that this contract between this boy and this buyer became voidable because of the age of the boy at the time of sale. When this man did not realize this man has remained honest, or this man has remained in good faith. So when he is required by law to return the property to the seller, he has the right to hold all these piglets. He is not required by law to return these piglets because Section 1376 in conjunction with Section 415 say that, okay, as long as a person remains in good faith, a person does not need to return the fruits, okay? The person is entitled to acquire the fruits which accrue on the property which is required by law to be returned. Okay, so even though this man is required by law to return this pig, under the contract between between this boy and this man, but this man does not need to return all these piglets. This man, the buyer, is entitled by law to just acquire the fruits accruing on this property which is required by law to be returned. Okay, so you have to be mindful of the legal consequences of the fruits which accrue on the property required by law to be returned as well. When a jurisdiction which becomes voidable is avoided, okay, then the law, even though the law directs restitution, okay, but if the property in question has some fruits, we will have to be mindful of the application of Section 1376 together with Section 415 as well in relation to the fruits accruing on the property required by law to be returned. Okay, so I think that means that we are going to have a break a bit. Okay, the lecture has been in progress. Okay, the lecture is in progress for I think that about 1 hour and 15 minutes. Okay, so that I think that now that we are going to call upon the break for about 10 minutes. Okay, so thank you very much for your attention. This is the first half of the lecture. We are going to have a break and then we will resume the class in 10 minutes time. Okay, thank you.